Welcome to Immigration Unpacked, real legal help for immigrants.
Hello and welcome back to Immigration Unpacked, real legal help for immigrants with Kevin J. Stewart. Kevin is a dedicated immigration attorney committed to helping individuals and families across California and beyond. My name is Kevin Rosenquist, and today's episode focuses on employment-based green cards, specifically the PERM labor certification process and the EB categories that allow professionals to become permanent residents in the U.S. Kevin, good to see you again.
Thanks, Kevin. Good to see you too.
All right, well, I had a hard time pronouncing it at first, but let's just start here. Could you explain how an employment-based green card differs from a temporary work visa, like ones we've talked about in the past, the H-1B?
Sure. And so people understand PERM is an acronym. It stands for Program Electronic Review Management. It's a mouthful. What it is the standard for many years for employers to sponsor folks to a green card, sponsor their employees for a green card. And the way it works is that they start out with what they call a prevailing wage determination. And then once that is approved, you do a recruitment. The employer does recruitment. And what that's for is the employer really has to show that they can't find someone in the market that will satisfy the requirements that they have for this position that they've already asked to provide a prevailing wage for. And then after recruitment is done and you are able to submit as the sponsor all of the documentation to show that you've completed that, then Department of Labor, which manages all this, they get to process everything that you've submitted and get you an approval. The whole process taking right now roughly about 2 years, maybe a little bit. Yeah, it's quite a long process. And actually there's one factor with our current shutdown. Department of Labor is affected. So there are companies that are still processing their PERM petitions, applications, but right now things are delayed.
So you talked a little bit about the process. Are there certain other steps that an employer needs to complete in order to make sure that they're successful?
Yes. The key thing with PERM is that you want to have a very well-defined role that you can consistently express to Department of Labor to avoid any issues with an audit. Department of Labor does sometimes audit these to make sure that the rules are being followed in terms of suggesting to Department of Labor that this is truly someone, or it's not someone. It's difficult because the way we look at it is they have an employee who they want to hire who is a foreign national. The way you have to put it to Department of Labor is that you can't find anyone other who can fill the same role that you are advertising for, recruiting for, knowing the whole time that you're really not going to hire anybody else anyway. Mm-hmm. You're just proving that you can't find them.
Right.
So that process is complicated, and you have to show that you made an honest effort to actually find someone in the market that could fill the job.
Okay. Yeah, that makes sense. Several different EB categories here. If you could walk us through these just to help everybody understand, there's the EB1, EB2, EB3. What are these? What's the difference between these, I guess I should say, and who generally qualifies for each?
Yeah, so for PERM, we're generally talking about EB2. In some cases, we're talking about EB3, which is just a slightly lower category. It includes more potential roles. But in most cases, it would be EB2 and under PERM. The other categories, which I think can talk about a little bit under this category, the other categories allow for self-petition. And so that would be EB1A, which is extraordinary ability, and EB2, national interest waiver, that's the self-petition form of EB2. You can apply for that self-petition, and that is for exceptional ability. It's, those two, I don't know how they landed on those definitions.
Those
To
two,
me,
yeah.
exceptional and extraordinary,
I don't
but
see a lot
anyhow,
of difference.
yeah, no. So, but that's the thing you got to keep in mind. Extraordinary is the top.
Okay.
Exceptional is just slightly below extraordinary.
Extraordinary is like Einstein level, kind of.
So yeah, that's people often call the EB1 the Einstein.
Mm-hmm.
It's easy, but there are many ways to qualify for EB1A, and as well EB2 NIW when you're looking at self-petitioning. And the way this has sort of evolved, when I mentioned the 2 years, so one of the things that makes people go more for the self-petitioning categories, one of the things is the time frame. The other is that many companies just aren't ready to make the commitment to an employee. Interestingly, there are some that are willing. Let's say, for example, they've had an employee that's been with them in H-1B category for years. For them, and they foresee keeping that employee on, they foresee a benefit to them, to helping them get a green card, they will enter into PERM gladly. So you do see that. I think what happens in situations like we're in right now, the environment for long-term employment is not great in areas like tech, particularly. So, it fluctuates.
And can you explain what the EB2 national interest waiver is, and how does that allow certain applicants to kind of avoid the PERM process overall?
Yes. So national interest waiver gives the self-petitioner, particularly, it gives them a way to argue this is to USCIS now, to argue to USCIS that they are prepared to apply their skills and experience in an area that is in the national interest. So each administration talks about areas that they back as being qualification for national interest waiver. There is a formula that is case law that sets out some requirements for national interest waiver as well. So what that does, what national interest waiver, what that refers to specifically is, we believe that this candidate should not need to go through the PERM process in order to be approved for a green card, basically. Not so much that approved for a petition and then be able to file their green card application, assuming that it's timely.
What would you say the challenges are that you see the most in these cases, and how does an immigration attorney such as yourself sort of help avoid these?
Yeah, right now the process for self-petition for either of these categories that we've talked about, it's just not a good environment.
Mm-hmm.
There's a move in USCIS in adjudicating these cases where they just don't want to approve them, for lack of a better way of putting it. And so, and it starts out with the RFE thing. Nowadays, there was a time where, a well-prepared case, I mean, this has been our experience. We had several of these approved, no RFE. The idea that you would have a case approved, no RFE now, it's just so unlikely. And it's not a reflection on the candidate. It's not a reflection on how it was prepared. Most of what we see, we would call it boilerplate. The RFE comes back, and sometimes you wonder, did they really actually look at the package? It's really, and all practitioners that do these understand this now. So, you're not hanging your head and kicking yourself when you see one of these. It's really just, okay, let's regroup. Let's get this, back in a form that it's going to go through. And even in that situation, you might get, after the RFE, you might get a notice of intent to deny. You might get a denial. It could very well, on a refile, sail right through, based on a different officer looking at it, based on a more fair adjudication. It's just it's a bit, but it's very, very technical in the sense that knowing what an approvable package looks like is where we come in.
Are you finding less people are applying for any citizenship or any visas or anything like that because of the turmoil?
I think a lot of people are reconsidering the U.S. visa and green card environment altogether.
Mm-hmm. Hard to blame them.
I think right now,
Yeah, hard to blame them. I mean, it's just so the culture here right now, or the temperature is just so high, and so kind of I don't know. I would be nervous if I was anybody coming into this country.
Yeah,
That's for sure.
yeah, no, I think it's completely understandable. I think the other thing is that if you're at the beginning of a path that you saw in the past as being fairly reliable, of attending a U.S. university, graduating with a bachelor's degree, working on a master's degree, working in your field, taking all the steps, making all of the investment. I mean, what I just talked about, I mean, that's multiple six figures. That's probably 300 some $1,000s of education expense. You're not making that much money when you come out because you're still not tested in the job market. So with all that investment, it makes sense that people would be reconsidering and maybe looking at other paths or other markets.
Mm-hmm. Absolutely. Can employment-based green cards extend benefits to someone's spouse, to their children?
Yes, and that's one of the main things you see. So, for example, one of the nice things about getting a petition approved through one of these processes, EB1A or EB2NIW particularly, or through PERM. If your PERM is approved and then you get the petition approved, you're immediately able to get benefits such as a work permit for a spouse, change of status for dependents. It just really extends your ability to have your family remain in the U.S. and continue to pursue your path. One of the areas that's very difficult, a lot of tech workers from India, as an example, also from China, they are in a more difficult situation because in the what we call the visa bulletin, it's a whole other discussion, but there's such a delay in these folks being able to apply for a green card after getting the petition approved. We're talking a dozen years, or more. And then there are other issues about how often these change. So, for example, we could say that based on how we think these numbers will move, that maybe it would be actually not 10, 20 years. It might be more like 40, 50, literally, in some cases, 90 years. Well, waiting 90 years to file a green card application, or I guess to get a green card, What's
I mean,
your life expectancy?
That's ridiculous. Yeah.
Yeah.
Even if you make it, you really want to do that at 90 plus years old?
This is the thing. And it's funny because in having talks like this and going through all of this, we work with people who understand what's going on in this whole environment. One thing that's in EB2 NIW and in these other categories, other than the EB1 category. So EB1, India, China, you still are looking at a pretty reasonable process to get to a green card. But that's the very top. That's that extraordinary ability again. So it for a lot of them, it's sort of like, well, I think I have a great profile for EB2 NIW, but it's not going to get me enough. It's not going to get me to where I need to be to get this done in a reasonable amount of time. So we need, as a country, we need to really look at this. We need to value high-skilled workers more. And give you an example. One of the proposals that's on right now, you hear about this, the gold card thing. I guess you give $1 million to the U.S., and then that allows you to get a visa. I mean, an immigrant visa, okay, and a green card. But they're talking right now about eliminating EB1A and EB2 NIW, taking away the high-skilled aspect, the exceptional or extraordinary ability, take that out of it, and just have it be based on how much money are they going to give the U.S.
Make it completely about money.
So, I don't know. We'll see. It's not a good look,
Yeah.
And an interesting thing is that other countries are paying attention. I know Canada's is really, Canada has issues with the perception of high-tech workers and competition with native workers also. I mean, that's another thing. But in terms of having the programs that they have, they're actually looking and encouraging folks who are getting out of the U.S. market for immigration. And then India and China both are looking at ways to retain their talent.
Mm-hmm. Mm-hmm. Yeah, that's a good point too. We don't think of it that on that end. They don't want to lose their people,
Yeah.
So, yeah. Well, it's definitely an interesting time, and be interesting to watch how all this plays out. Thank you very much, Kevin, and thank you for joining us on Immigration Unpacked, real legal help for immigrants with Kevin J. Stewart. If you're exploring employment-based green cards, whether as an employer or an employee, visit oaklandimmigrationlaw.com to schedule a consultation and get clear guidance. And as always, don't forget to subscribe and leave us a review. We very much appreciate it. Kevin, thanks so much for your time. Really interesting stuff. Thank you.
Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.